4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
And it is a very good morning to Andrew Bell from Bell and Senior Lawyers. Good morning to you, Andrew.
Morning, Colin. Thanks for having me back.
Well, I'd like to welcome everyone to our brand new show, Legal Matters, and understand that it is also a brand new sponsor, Bell and Senior Lawyers, not to be confused with the old sponsor. So bear that one in mind. This is also your opportunity to get some free legal advice live on air. All you need to do is have your question ready and give us a call right now. You've got 25 minutes to the end of the program, so do not leave it to the end. 07 55 20 8888 is the number. We'd love to hear from you this morning. And I've got a good news story, Andrew. Your lovely wife has just been accepted to the bar.
Absolutely. Yesterday I had the genuine pleasure of moving my wife, Rebecca, to be admitted to the legal profession in a ceremony in the Supreme Court of Queensland. So she's been working on that for a long time. What I want listeners to appreciate is what that represents in terms of the journey that she's been on. I'm sure she doesn't want to make a fuss because that's not who she is, but she's been studying law while raising 5 girls. She started this process before our youngest was even crawling, and that girl is just about to turn 5 years old. So wow. It's just a level of dedication that most people can't imagine, and I'm very proud of her.
Yeah, that's absolutely fantastic, especially raising a family at the same time. That was a monumental effort. But it does bode the question, what does it take to become a lawyer in Queensland?
Well, it's actually a more difficult process than people realise, and it has a number of stages. The first thing to do is to complete a recognised law degree at a recognised university in Australia. Typically, you need a Bachelor of Laws or a Juris Doctor for postgraduate students. And that takes 3 to 5 years of full-time study, depending on the path that you take. And it can take even longer if you're fitting life around it and you can't actually do every subject full-time. Once you graduate, that's not the end of the road. You then have to do something called practical legal training. So you actually have to go work in a law firm, write letters, and get assessed not just on your technical understanding of the law, but your practical application of the law. And then once you finish that, there's even more steps again. The third process is the admissions process. So to actually get admitted, you can have passed everything previously and still not get approved by the court. You have to put in paperwork, affidavits, numbers of steps. You go to the Legal Practitioners Admissions Board, and then they assess if you met all the technical and the moral requirements. And then you have to then submit that to the Supreme Court, who then make the ultimate decision. And then you need a solicitor or a barrister to formally move to say that you're a fit and proper person. And after all of that, it's only if the court considers that you're a fit and proper moral person to practice the law and you've done everything else, can you then get admitted. So, as I said, it's a long and difficult journey.
A fit and proper, I'm assuming, is the all the study requirements and all of the information requirements. Moral is the
so
word.
Fit and proper actually comes down to do you have respect for the law? There are people who've been knocked back because of excess speeding fines. There's people that have been knocked back for not paying for travel on public transport. You have to declare anything, whether it relates to your tax, any fines you've received, any disciplinary processes you've even had as a volunteer, and they'll assess all of that to see whether they consider that you're good enough. And once you're in, you have an ongoing disclosure requirement to make sure that if you do anything that might cast shade on your reputation or ability to practice the law, that they can reassess whether you're still fit and proper to be a lawyer. So it's
okay.
Yeah, it's not just do the paperwork and get in.
Do the study, tick the boxes, and you're in. You did raise the word moral. What's the measuring stick there?
Well, it comes into that fit and proper person. Are you actually doing things that you would expect someone to do? So as lawyers, we take a lot of we get a lot of trust from people. People tell us their deepest secrets. We have obligations not to disclose those things. We also have an obligation to the court. So when you get sworn and admitted, it's like you're sworn if you're giving evidence every time. So I'm under a duty not to mislead the court, for example. So just because it might be in my or my client's best interests to be able to say something happened or didn't happen, are you the right sort of person who stands up and says, even though that's what would be nice to put in that document, that we actually put the truth into it?
Nice. All right. Well, that's very interesting, Andrew. We've got our first caller this morning, and that is just a reminder that this is a talkback program. We'd love to hear from you this morning. 0755208888 is the number to get some free legal advice live on air. It's a very good morning to Jeffrey. Jeffrey, ask your question of Andrew.
Good morning, Andrew. Thank you for taking the time. I'm just preparing an enduring power of attorney, and I would like your opinion on whether there's any benefits or that of also having an Advance Health Directive if your enduring power of attorney also includes health and finance.
That's an interesting question. I think it depends what you anticipate. So, and the availability of the people who are acting as your attorney. So a binding health directive or an advance health directive will be on file with Queensland Health. It gives them an understanding of the decisions that should be made. So if you get brought into hospital at the last minute and someone needs to make a decision around what to do with you, and that's already documented, then there's a good chance that your wishes will be followed. If you're not anticipating that, and your attorney is briefed on what you'd like for medical matters, then they're able to give that information to your doctor. So I guess it really depends and comes down to your personal circumstances. For most parties, we find that an enduring power of attorney is sufficient if their attorneys are readily contactable.
Yeah, okay, yeah. Because I suppose what I'm just thinking about is whether you have an accident that it can happen at any age, at any time. On that, but if I have the enduring power of attorney and set out my wishes in that, then normally the people would be contacted any case, yeah.
Provided that they know how to contact that attorney. Maybe you need something in your wallet that indicates if there's an emergency and you're not conscious that that's who they should contact.
Okay, yeah. All right, okay. So there's a little bit of benefit by being in the hospital system, but that's about it.
There is. And you might want to discuss that with your GP next time you go and talk with them.
Okay. Thank you very much. I was just getting confused whether it would be confusing with having something in an enduring power of attorney and then an Advance Health Directive, whether one would override the other, but
that's
not
not something that commonly happens, but I would make sure that if you're doing the Advance Health Directive, that the directions you give your attorney are consistent with what you put in there so you don't get that situation arising.
Yeah, okay. All right. Thanks very much.
Thank you, Jeffrey.
Very good advice. Thank you.
Good on you, Jeffrey. Well, thank you for the call. All right, if you'd like to have your question answered just like Jeffrey did, 0755208888 is the number. And we now move to John. John, good morning to you. Ask your question of Andrew.
Good morning.
Morning.
My question is it a good idea to add a codicil to an existing will, or should I get a new will prepared?
So a codicil is, for those who may not be familiar, is an addition to go on to the end of a will. And when wills were much harder to draw up, they were much more common. Our recommendation to clients is not to do them and to draw a fresh will. So then there's no differences of opinion, but I guess it depends what you want to add to the codicil.
There was only two little things that I wanted to add, but I can see your point, so I'll go ahead with the new will.
Excellent.
Yeah, and how did you pronounce that? I thought it was cortical.
It's codicil.
Codicil, all right. Thank you very much.
No worries.
Thank you, John. All right, 0755208888 is the number to have your question answered live on air. It is a legal program, so we'd like to limit it to legal questions. 0755208888. Did we adequately cover off what it takes to become a lawyer in Queensland?
I think we did, unless anyone's got any questions, but it's definitely a worthwhile thing to do, and it's a long path.
It is indeed. Now, Andrew, we were in the middle of a discussion last week, and we were going to tidy that up. I'm looking forward to our bigger discussion. So we were talking about wills, were we not?
We had a call-in caller who asked about when is probate required in Queensland.
There you go. So let's answer that question quickly.
So quickly, I'd said that it was around $100,000 or when property was involved. It's a bit more nuanced than that. Normally, I get involved when people are transferring houses or aged care accommodation deposits for probate, but on research, it's not just that. Some banks will have a threshold of between $10,000 and $50,000 that they won't release funds from if someone's deceased without the will going through probate. Similarly, shares and equities between $15,000 and $25,000, depending on the where they're registered, will require probate as well. And there has been some questions around superannuation and probate, but superannuation typically goes down a different path and requires a binding death nomination as part of the superannuation directions to the trustee, and therefore it doesn't require that. So if you do pass and your significant assets aren't property, there are limits that you need to your executor will need to consider to see whether they go through probate. And if they think it's likely, I recommend you do it as soon as possible, because it can take 15, 16 weeks to get through all of the necessary paperwork to have probate granted.
15 or 16 weeks. Okay, all right. Well, that is a bit of time. All right, our topic of the day today is debt collection. I'm quite excited about this one because there's a lot that I really thought I knew but didn't really know. So let's move into that. Andrew, let's start simply. Someone owes me money. What do I do?
Well, this is a question that comes up very frequently, and giving advice at the Community Legal Centre, my Community Legal, it's often a question I get asked when people are saying, I loaned this money and it's not getting paid back. And my first step is, what were the circumstances around the loan? To enforce something in court, it needs to be sufficiently certain. So was there a written agreement? Is there anything before or after the loan that would evidence that money changed hands, and most importantly, that it was intended to be paid back, and how it was intended to be paid back? And without the answers to those questions, debt collection can be very difficult. So if you're dealing with a company, companies typically have all of their terms of loans in writing. And they do that because without them it is much more difficult. And I'd recommend that anyone who is going to loan money to people make sure that there is some evidence in writing, even if it's text messages. Hey mate, just to confirm, you wanted $1,000 lent to you. I'll expect that paid back in the next couple of weeks, and then get an okay, no problem reply. Even something like that is much more helpful than just opening up your wallet and giving or transferring some funds and then hoping that they do the right thing and pay it back.
Look, it's interesting. It was explained to me at one stage that people find that, I don't want to ask them for anything. They're kids, they're our kids, or they're our friends, or they're this, that, and the other. You don't know what could happen in the future. They could end up on drugs. They could end up with dementia. They could end up with any number of things that mean that they do not remember or do not adhere to the terms of the loan due to illness or due to other circumstances. So it's just best to have that safe backup.
Absolutely. If without something in evidence, if you want to collect on the loan and you need to go to QCAT or the Magistrates Court or any of the other options we might discuss later, if you turn up and just say, I gave the money, and they say that was a gift, how are you going to get around that? So you need to meet what we call the civil standard, or 51%. Is it more likely than not that this money changed hands, and is it more likely than not that it was a loan and intended on being a loan? So if you're going to give money to people, I would advise that unless you're prepared to never see that money again, to have some sort of arrangement or in something in writing that evidences that that was going to be a loan, and also evidences how it's going to be paid back. Because even if someone agrees that it's a loan, one of the things we see is people say, yeah, but that didn't need to be paid back for 5 years, or that was intended to be paid back when someone passed or I inherited or something else. So even if you can establish there was a loan, even if you can establish money went over, unless there's enough certainty, you're not going to see your money back on the other side.
What difference does it make if there's a written loan agreement? And I think we just covered that one off, basically, didn't we?
Indeed, we did. So, yeah, if you're loaning money even to close family members or friends, get it in writing. It protects both sides and avoids the kind of disputes that end or destroy personal relationships.
All right, final 10 minutes in the program. We'd love to hear from you. It is your program. You have the opportunity to have your legal questions answered live on air. 0755 20 8888. And it's a very good morning to Robert. Robert, ask your question of Andrew.
Yeah, just a simple question. Just with a simple will, what sort of price would it cost?
I think it depends where you're going to go, Robert. You could start with drafting it yourself from a do-it-yourself will kit. And I believe they're $32.95 from Australia Post. You could go to the public trustee and they will do wills for you. The catch with those is that they will charge an administration fee on your death, so you might want to look into what the fees and charges are. And otherwise, if you go to a private lawyer, I'm hearing between $400 and $600 is a good rate, and if it's complicated, it will go up from there.
All right, thank you very much for that. You have a great day.
You too.
Thank you, John. All right, if you'd like your question answered by Andrew from Bell and Senior Lawyers, our brand new sponsor of the program, 0755 20 8888 is the number. What if the loan, we're talking loans and loan agreements, what if the loan was secured against property or another asset?
So this is something that's rarely done person-to-person loans, but it's often done with business loans or business to individual loans. And what we mean by security is, did you pledge that something that you physically own could be sold or transferred in the event that it's not paid? And there's been a lot of changes in this area over the last couple of years. A lot of people may not have heard of the PPSR, the Personal Property and Security Register. However, if you have bought a car and you do what's called a revs check, it will check beforehand to see if that car is secured. So I would actually recommend, if anyone's buying a car, it's only $2 to do those checks, because if a property is secured and it's transferred by someone who's loaned money against them, the best title to that is not actually the person who sold it to you, it's the actual person who lent the money. So if property is secured, most common will be familiar with mortgages. You don't pay the mortgage back, they can sell your house. But you could have that against industrial plant and equipment. You could do that against a business you own or shares you own or all sorts of other things. And the benefit for the lender of having security is that if someone goes bankrupt, typically if they don't have a secured loan, then they can't get the money returned to them. If it's secured, then they can at least sell that asset and then retain some of their money.
Okay. 0755 20 8888 is the number if you would like your question answered by Andrew Bell from Bell and Senior Lawyers. 7 minutes left in the program. Now is the time to call 0755 20 8888. All right, what if there is no security and how do you get a court order?
So that's the most common scenario if I'm sure most of our listeners are lending money to people, that they're doing it on the expectation that someone will do the right thing and get it back. So again, you need to gather the evidence together of what actually constitutes the loan. And enough to be able to prove that it's sufficiently certain that the money was transferred, there was an intention for it to be a loan, and the terms of the repayment of the loan, and then any repayments that have been made to prove that the terms haven't been adhered to. And then the question then comes down to how much money was loaned. So for debts up to $25,000, you can go to QCAT and you can go back and listen to our How to Do a Minor Debt Complaint in QCAT in one of our previous episodes. If it's between $25,000 or $150,000 or there's some other circumstances and it's less than $25,000, you can file in the Magistrates Court. For amounts typically between $150,000 and $750,000, you'd go to the District Court, and then above that you'd go to the Supreme Court. If you're looking at those large amounts of money, I would strongly recommend that you engage a private lawyer, because typically you can actually claim your costs back on loan amounts in the court. So once you've established the court, you then need to do a claim and a statement of claim as to evidencing what you had, and then you need to serve that on the other side, saying this person was going to pay me $50,000. They're going to repay it in five amounts of $10,000 on the first of every second month. We got the first two payments and we didn't get the amounts after that. So please pay $30,000 plus costs plus interest. And then it will then eventually get set down for a hearing where you can make that claim.
This is a Talkback program. It is about you. 0755 208888 is the number to have your question answered by Andrew Bell from Bell and Senior Lawyers. 5 minutes to go. Do not leave that question too much longer. And once QCAT makes an order in my favour, does that mean that the money arrives straight away?
Unfortunately not. It's not that simple, Colin. So if any court, if QCAT, we've talked before about registering judgments in the Magistrates Court, but if any court makes a judgment, you then have an order, and then it's up to you to get that order enforced. So, and this is one of the things that frustrates people the most as part of the process, is they think, good, I got that order for my $30,000 plus costs, but then you actually have to find some way of getting it back. Now, if they don't pay it, then there is default interest. If you do have to involve a bailiff or other things, then you can charge them for that, and you typically have 6 years to recover the funds. But it can be quite a difficult process to go down, and sometimes it involves making people bankrupt. Sometimes it involves getting a bailiff to force sell a house. Again, right. It's not as simple as just walking out with a bit of paper and a cheque.
And you can't just say, transfer me the money, please.
Well, if it is in the bank, you can get an order from the court to have the bank transfer the money across, but often people are aware and they may have transferred the money out of their bank in their name.
All right, we're in the final moments of the program. Their last chance to have your question answered by Andrew Bell from Bell and Senior Lawyers. It is a very good morning to John. John, ask your question of Andrew.
John, I'm closing my super fund. What does the solicitor do? What part of it is he involved in?
So when you say you're closing the fund, is this a self-managed super fund that you no longer want to administer, or are you talking about removing your funds out of super?
Oh, that's a good question, isn't it? Yeah. Well, I am removing the funds out of the. Yeah, no, look, I'm closing the fund. Andrew, no, I'm closing the fund.
John, is it a self-managed super fund or is it an industry super fund?
No, a self-managed super fund.
Okay, well, typically then you'd have to wind down the companies, resign as a director, go through the ASIC forms. That's not normally something a solicitor would help you with unless there were loans or outstanding documentation that was required by, say, the ATO or an auditor. Typically, I'd go to an accountant to be able to do that.
So the solicitor doesn't really come into it, or what? Yeah.
Not typically if you're distributing the funds and then ending the trustee relationship. That should have all been set up on how to do that when you set up the self-managed super fund.
Sorry, when did I?
No, I'm saying when you set up the fund, there would have been a trust document. Typically, exactly. That would be drawn up by a lawyer, and that will typically mention about how the fund ends. And provided you meet those criteria for how it ends, and you close the trustee company, and you close the books on the company, and you have a final audit, you don't typically need a lawyer's involvement to do that.
I thought you did, yes. All right, well, that's... And the time factor there, Andrew, on the... what's a normal time factor to conclude all this, get it together?
I think it would depend on the complexity of the fund, John. Speak to your accountant. If they recommend seeing a lawyer, then speak to a lawyer.
Yeah, look, it's more a financial question for you, John.
No, that's fine. Thank you very much.
Thank you. All right. Well, we've got about 2 minutes left in the program. Andrew, would you like to do a bit of a summary, and we'll tackle the next questions next week? Might have to be a two-parter.
Another two-parter. We're making this a bit of a habit, but it's great to have people calling in today. Thank you for that. I think takeaway is, if you are dealing with money and it is something that you want to see back again, then while it might feel difficult, go through the process of writing something up. It doesn't have to be exhaustive with lots of particular terms and conditions, but have something signed and acknowledged. You know, even if you video yourselves just talking through what the deal is, something that you have in the future that you could use to rely upon to have evidence that the money that you transferred to someone, there was an intention on coming back to you. And I think you would live a much easier life and preserve a lot of relationships if you have that, compared to having the complete trust option.
Yeah, absolutely. Andrew, fantastic information. Look forward to the continuation of the discussion next Tuesday at 9 a.m. Thank you to all those people who called in this morning. It is your show, and it is better for it when you do call in and ask your questions. Well, Andrew, thank you very much for your time this morning.
Thank you. I'll talk to you next week more about debts and debt collection.
We'll look forward to your company then.
Wills, probate, powers of attorney or property matters. Legal issues don't need to feel overwhelming. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 3133 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.